$649, including the maintenance fees. And unless there is something that we are unaware of, we request at this time the final judgment be entered.
All right, give me just 1 minute, please.
I panicked, Your Honor. I saw you looking at me with a blank stare. I thought maybe my mute was on.
No, maybe that blank stare is just my default setting.
I was very nervous all of a sudden that I had said all that and you never heard it.
No, I heard the whole thing. I was looking at, honestly, I had forgot to start the YouTube live stream. So I was doing that and listening to you at the same time. Okay, so Charter Club versus Marco. I did hear everything you said. I noticed that both defendants, Renee and Isle Zimmerly, were served and defaulted 11/30 of 2020. The motion went out for the instant motion January 12th, 21, notice January 28th, 21. You do have affidavits in the court file for principal, fees, and costs. Just for everyone's information, there is no one present with me in the courtroom, so they're not here, nor are they in the waiting room, although again, they were properly served and noticed. And so based on the foregoing and your argument, your motion is granted. And I'll also admit that I don't have that paperwork. I know you always send it in advance, so it's in my office. And the only thing I need to do, Mr. Bell, as you know, I like to, of course, review the proposed order and especially compare the legal description in the final judgment with that in the complaint. So once I do that, I'll execute your judgment, okay?
Thank you, Your Honor. We did forward that to you via overnight mail express January 12th of 2021. It was forwarded from my legal assistant, Milan Gillum, to Your Honor at the JA does not have it in her possession. Just let us know. We'll be happy to forward another copy.
Will do. Thank you,
Thank
Mr.
you, Your
Bell.
Honor.
Have a great day.
You too. Bye-bye.
Thanks. Bye-bye. Okay. Also on our 10 o'clock docket is Trust Bank versus Santos 20 CC 1715 plaintiff's motion for summary judgment.
Good morning, Your Honor. Amy Winarski, excuse me, on behalf of Truist Bank. And I believe Ms. Jennings is on as well. I don't see Mr. Santos on.
All right, so it is Truist Bank. All right, thank you. I misspoke.
Yes, sir.
All right, so we have counsel Winarski for the plaintiff, and I do see Shelley Jennings. I see your name. Can you take your audio off mute? Ms. Jennings.
Good morning, Your Honor. Good morning, Your Honor.
Do you have video?
Yes, I do.
Okay. Are you trying to figure that out?
Yes, let's see here.
There should be a little camera that you click off. There should be a red line that if you click it off, it should go on.
Yeah, it says unable to make sure your camera is powered on and connect your computer. It is powered on.
Well, here's the reason this is important. We're here for a motion for summary judgment. As you know, the plaintiff, Truist Bank, is asking me to enter a judgment against you and Jose Santos. And if I cannot see you, then I cannot swear you in.
Okay, let me work through just 1 second. I'm trying right here. I think I have it.
Your Honor, do you want to pass us while she tries to get her video and come back to us?
I've thought about that. My last case at 10 o'clock might take a little bit, so let's give her just another minute to see if she can figure it out, and then I will do that if necessary.
Okay.
I think I have it here. Let me just one thing. I'm so sorry. I had it before you came on, and I don't know what
Well, that's good. Then at least we know it's possible. You have the equipment to do it. Why don't I come back to you, Ms. Jennings? Ms. Winarski,
Okay.
thank you for the suggestion.
Okay.
I'm
Thank
gonna
you.
take my last 10 o'clock case and then I'll call you back.
Thank you so much.
Okay, sure. In the meantime, just please put your audio back on mute. Okay, our last case on the 10 o'clock docket is Poole versus Coleman, 20 SC 1822, plaintiff's motion for summary judgment. Who's here
Good
for
morning,
that case?
Your Honor. Gary Green for the plaintiffs.
All right, good.
The Mayan Poole.
All right.
John Silverfield for Ms. Coleman.
All right, good morning, gentlemen. And Mr. Green, we're here on your motion, correct?
We are, Your Honor.
And are you ready to proceed?
I am, Your Honor.
And Mr. Silverfield, you ready to proceed as well?
Yes, Your Honor.
Mr. Green, go ahead, sir.
Yes, sir. Judge, this is a small claim for damages for violation of Florida Statute 8349 pertaining to a security deposit for a residential tenancy. It's undisputed, as the motion sets forth, that plaintiffs had a 1-year lease for the subject property. It's undisputed that they paid a security deposit in the amount of $2,500. And then attached to the motion are affidavits from the plaintiffs that indicate that they never received any notice with regard to any intention to retain the security deposit from Ms. Coleman, and that they also never received a return of their deposit. The statute is clear and unambiguous, and as set forth in the statement of claim and in the motion for summary judgment, the statute provides that if the 30-day or the notice isn't provided within 30 days, the landlord forfeits the right to the security deposit. Any claim for damages that the landlord may or may not have can only be brought after the tenant receives the security deposit. So our claim is based upon that statute. A response was filed to our motion for summary judgment. Interestingly, the response does not dispute the facts. In fact, it doesn't even try to dispute the facts. Instead, they do a couple of things. First thing they do is they allege that our evidence is insufficient, Judge. It states that plaintiffs simply chose to offer merely conclusory self-serving statements, which are framed in terms only of conclusions of law, while also referencing various documents without attaching them. For example, plaintiffs claim they enter into a valid lease. It is not annexed to either affidavit, and they offer no proof of the amount of the security deposit. I would beg to differ, Your Honor. The lease is attached as Exhibit A to the statement of claim, and it clearly states the amount of the security deposit. In fact, with regard to the allegation in the statement of claim that is relevant, let me get there. The defendants admit that the Exhibit A is the lease, purports to be a copy of the lease. And then with regard to the amount of the security deposit, they say that Exhibit A speaks for itself. And again, it's attached as Exhibit A. As far as the allegations or the factual statements that are made in the affidavits, they're not at all conclusions of law. They are simply that we never received we paid a security deposit, we moved out, we never received a security deposit, and we never received a notice. It's as simple as that. They then turn, again, in the absence of evidence to the contrary, to an assertion that somehow they can rely on their affirmative defenses. And if you look at the answer, Judge, there are 6 affirmative defenses that are pled. It's our contention that each of those 6 affirmative defenses is absolutely legally insufficient. And were we not in small claims court, we could have done discovery to deal with those potentially on the facts, because if you look at the affirmative defenses, there are absolutely no facts given to support any of them. All right. But more importantly, again, they're legally insufficient. And I'd like to go through each briefly so that Your Honor can understand the argument. The first affirmative defense, and I'm just going to quote the entire statement, plaintiff's claims are barred by its prior breaches of the lease between the parties. Judge, this is not a breach of lease case. This is not a breach of contract case. This is a case for damages based on the statutory language that is clear. So a prior breach would only be a defense in a breach of contract case. Legally insufficient under these facts and under this statute. The second says plaintiff's claims to relief are barred because it seeks inequitable relief. I'm not aware of that being an affirmative defense, but clearly the legislature thought the statute was equitable, and the facts again are uncontested. This is not a court of equity, as Your Honor understands, and again, I'm not even familiar with that defense. The next is that plaintiffs have failed to properly state a claim which relief may be granted. Clearly, Your Honor can decide that issue. The claim is statutory. Again, and the facts are undisputed. The next is that plaintiff's claims are barred by its unclean hands. Judge, I would cite Your Honor to Hauer versus Thumb, which is probably the oldest Supreme Court case to address this issue, at 67 Southern 2nd 643 from the Florida Supreme Court in 1953. Unclean hands is only available as a defense in cases that seek equitable relief. Again, this is not a court of equity. Plaintiff's claim is for damages, money damages, as provided in the small claims scope, or the scope of the small claims rule. Unclean hands is not you see it in foreclosure cases, you see it in injunctions, you see it in specific performance. It's an equitable remedy or an equitable defense that says a plaintiff can't come into equity, a court of equity, and ask for an equitable remedy when they've themselves acted inequitably. Well, again, this is a claim for damages based on a statute. The next is that plaintiffs have failed to properly complete all conditions precedent to bringing this action. There are no conditions precedent in the statute as an initial matter, Your Honor. But moreover, and defendant has invoked the rules of civil procedure in this case. And with regard to pleading special matters, Rule 1.120 subsection C states that a denial of a condition precedent, performance, or occurrence shall be made specifically and with particularity. And again, there is absolutely not one scintilla of fact attached to affirmative defense number 5. Affirmative defense number 6, the last, Judge, is that, and again I quote, plaintiffs have failed to mitigate their damages. Again, Judge, that's a contract or even sometimes a tort defense, but it wouldn't be a defense to a violation of this particular statute. I'm not sure how they possibly could have mitigated their damages. Again, it's just inconsistent and wholly applicable to this set of facts and this cause of action. And, I would ask the court, could they have pled assumption of the risk, or could they have pled comparative fault or COVID-19? I mean, just because you plead a defense in your answer doesn't make it valid, and it doesn't make it legally sufficient. I don't even think any of these defenses are at all applicable, much less legally sufficient. With that said, I think the evidence is clear. It's obviously undisputed. The affidavits contain statements of fact, material fact, the only relevant facts. There are no legal conclusions whatsoever contained in the affidavits. And I would rest on the evidence presented, including the complaint that is attached as Exhibit A to the statement of claim. Not the complaint, the lease, excuse me, Your Honor.
All right, thank you, Mr. Green. Response, Mr. Silverfield.
Your Honor, just briefly, obviously, this case is one of these one of these very straightforward, simple cases that we've been trying to settle since the beginning. And frankly, what the issue is coming down to, and I think it's very ironic that Mr. Green talks about the fact that you can't proceed on any kind of damages until the landlord pays the security deposit. However, in trying to settle this case and resolve this, they're trying to force our client into signing a release of all claims.
Judge, I would object to the relaying to the court of settlement communications.
I don't think that's settlement communications at all. This is the one contention. We're trying to resolve this case, Your Honor, and now we're wasting more and more attorney's fees. And if he hadn't brought that up in his response, in his initial argument, then I would have never said that. But the fact of the matter is, this is a big waste of attorney's fees. We want to get this done. We've been trying to get this done. And at the end of the day, I'm not even sure how it's possible for us to even be on a summary judgment motion where probably Mr. Green's fees are going to be more than what the amount in controversy is. So not really sure what we're supposed to do in this situation. And that's really where we're at right now. We've been trying to resolve it since the beginning.
Well, but you haven't yet addressed the validity of his motion for summary judgment. How about addressing that based on the facts of the case?
I mean, Your Honor, again, it's trying to prove a negative. They're saying they didn't receive notice. I think it's a question of material fact. And at the end of the day, saying that we sent something and attaching it as an exhibit and swearing to the authenticity of it through an affidavit is one thing, but saying we didn't receive something is a question of material fact without being able to prove that simply based on a self-serving affidavit. And I think I made that pretty clear in my response in opposition. And that's essentially where we're at.
Okay. All right. The last time I reviewed this case was yesterday. Have you filed any affidavits in opposition to the instant motion?
No, Your Honor, we just
an
argument that they're trying to prove a negative, which was insufficient. And
I read that.
That we're not required to provide evidence if they have insufficient evidence on their side.
Okay, well, let me make some comments about my review of the file, Mr. Silverfield, and then I'll give you a chance to respond. The instant motion, of course, is based on 8349 subsection A, and the relevant provision is if the landlord fails to give the required notice within the 30-day period, he or she forfeits the right to impose a claim upon the security deposit. There's another subsection further down that says there is a certain circumstance where a tenant might waive that notice requirement if they abandon the property or vacate the property early. So the first point I want to address is I think Mr. Green accurately argued earlier that this is not a case of a breach of the lease agreement. The lease agreement, based on my review, is attached to the statement of claim. Per the defendant's answer, Mr. Silverfield, you say that the lease speaks for itself. And I agree with that. And the lease does say that the tenancy expired on October 31st, 2019. And I've got two affidavits from the plaintiffs in the instant case tenants that they did in fact vacate the premises on October 31, 2019. So that's a timely termination of the lease agreement. So I haven't seen any allegation to the contrary. I haven't seen any assertion that they vacated prior to the expiration of the lease. And why is that relevant? Of course, that's relevant because the landlord is relieved of the notice requirement if in fact the tenants vacate early. That's further on in that particular statute. Doesn't apply in the instant case. There is no allegation that they left early. So that statute does apply, and it's very clear on its face. And I know that in your response, Mr. Silverfield, you indicate, well, they haven't even attempted to address our affirmative defenses. And so what I did is just, I pulled a case quickly. I know that there are a lot of case law, a lot of cases, both of you are familiar with them on conclusory arguments with respect to affirmative defenses. I pulled this one, just one, because the language in it is practically identical to, I think it was affirmative defense number 3. And this case is Luxottica Group versus Cash America East. And the site, this is a federal case, 198 Federal Supplement 3rd, 1327 from 2016. And on page 3 of the opinion, it says defendant's first affirmative defense states, and then it quotes it, the amended complaint fails to state a claim upon which relief can be granted. Your affirmative defense number 3, plaintiffs have failed to properly state a claim upon which relief may be granted. Again, virtually identical. And the opinion goes on to say the plaintiff argues that this is not a defense, but a conclusory denial. The court agrees. And then it says, C. Smith striking boilerplate denials as devoid of specifics. Now you've got nearly, again, identical language in your third affirmative defense, and all 6 of them are likewise conclusory and boilerplate. So I'm not persuaded by the response to the motion that they have failed to adequately address your affirmative defenses. I want to cite another case. And this is therein, D-U-R-E-N-E versus Alcime, A-L-C-I-M-E, 448 Southern 2nd, 1208 from 1984. Excuse me. And this is, I think, Mr. Silverfield, you preface your argument with this is very straightforward and simple. And this case law, this particular opinion agrees with you. Under head note 3, when a tenant files suit for the return of a security deposit, the procedure is simple and straightforward. All the trial court has to do is to determine whether the money was held for more than 15 days after the tenant vacated the premises without any notification by the landlord, excuse me, that he intended to make a claim against the security deposit. If the determination is that the landlord did so hold the deposit for more than 15 days without notifying the tenant of any claim, the statute requires the security deposit to be returned forthwith. It seems to me, based on my review of the case and my review of the case law applicable to the case, that if in fact your client sent out the notice, which again, pursuant to the statute has to be in writing, sent by certified mail, now would be the time to tell me that, right? In a motion for summary judgment, wouldn't you file an affidavit to that effect and attach the notice and say, here it is, Judge, we did it?
Yes, obviously.
Okay, and when the answer says things, your answer says that, I think it was your response to the statement of claim. In the 6th paragraph of the statement of claim, defendant never sent any notice. Your answer was any notice is vague. When I read that, Mr. Silverfield, and then I review the file on the day before the motion for summary judgment, and there's no affidavit in opposition attached with the notice, it leads me to believe that's just because you didn't send it. If I'm wrong, tell me now. Now's the time.
I obviously that would have been clearly we would have done that if it did exist.
If it exists.
So, okay. I mean, and again,
go ahead.
This case again should not even exist. We've been trying to pay it back the whole time since day one. I mean, I don't even.
Okay.
I'm not really sure what the position that I'm put in right now is a difficult one.
To the discussion of settlement discussions, although I do withhold the opportunity to respond to that, I hope, and to the other misstatements that were made with regard to that.
Well, hold on a second, Mr. Green. Let's let Mr. Silverfield finish. I told you before I made my comments that I'd come back to you and give you a chance to respond, and you've done that a little bit. But is there anything else you want to say, Mr. Silverfield, before I rule on the motion?
No, Your Honor.
Mr. Green, I know you're chomping at the bit to say something, but I am on the verge of granting your motion. Is there anything else you want to say?
I have nothing further to say.
Motion is granted, and I'll ask you, Mr. Green, to send in a proposed judgment.
Your Honor, I would also move that you enter an award as to entitlement to attorney's fees pursuant to statute.
Mr. Silverfield.
We would object to that. We would object to that, and we would say that we should be able to argue rather than the court simply enter that at summary judgment.
Well, do you disagree that they're the prevailing party?
Well, obviously not.
Okay, I know you chuckle, but isn't that what it comes down to?
Yes, Your Honor, but okay, I understand. That's fine.
Okay, motion is granted, and that request regarding entitlement likewise granted. Anything else from either one?
No, Your Honor, other than that, I'll obviously include in the order that you'll reserve jurisdiction to determine the amount of the fees.
Okay, very good. Thank you both. Have a great day.
Thank you, Your Honor.
Okay. Miss Winarski, I'm coming right back to you. Give me just a minute here, please, on some paperwork. And this is, no, I'm okay, thank you. This is Truist Bank versus Santos, 20 CC 1715. Miss Winarski is still here for Truist Bank plaintiff. And we have Miss Jennings here, audio and video. Miss Jennings, can you hear me?
Yes, Your Honor.
Okay. So, Miss Winarski, your motion for summary judgment, are you ready to proceed?
I am, Your Honor. Thank you.
All right, go ahead.
Yes, Your Honor. This is a motion for summary judgment. The underlying debt is a joint credit card between Ms. Jennings and her ex-husband, Mr. Santos. They were both served. Mr. Santos has not answered. Ms. Jennings filed an answer objecting to the amount, saying the amount's not correct and that it is Mr. Santos's responsibility. They're divorced now. Under the law, if it's a joint account, any divorce or marital separation agreement has no bearing on third-party creditors. They're both jointly and severally liable for the debt. Of course, if Ms. Jennings has something in family court that says he's responsible, she can follow that up in family court, but it has no bearing on the third-party creditor. As well, the statement that the amount's incorrect is insufficient as a matter of law. We had an affidavit with the last few years of statements showing the amount under the case of Loyal versus Deutsche Bank, which is 21 Southern 3rd 907 3rd DCA from 2009. The court held that it says, we note that some of the affirmative defenses and statements in the affidavit in opposition are conclusory. Where there are no facts pled to support general allegations of affirmative defenses, the defenses are legally insufficient. In this case, there has been no affidavit in opposition, and the answer merely states that the amounts are wrong. That's insufficient as an affirmative defense, Your Honor. And we would ask that the court enter summary judgment at this point.
All right, thank you. Ms. Jennings, will you please raise your right hand to take an oath? Ms. Jennings, can you hear me? Ms. Jennings, can you hear me?
So there, my screen went blank.
Madam Clerk, can you hear me?
I can hear you, Your Honor.
Me too.
All right, thank you. Ms. Jennings, can you hear me?
Yes, Your Honor. Yes.
Ms. Jennings?
Yes. Yes, I
Okay.
can hear you.
I think your screen is frozen. I can't see you.
Yeah, I can hear you, Your Honor. I can hear you.
Okay,
Your Honor?
that's okay.
I can hear you.
All right,
Your
that's
Honor?
good.
Hello?
Hello, I can hear you.
Your Honor? Can you hear
But
me?
yes, I can hear you, but your video is frozen.
Your Honor? Can you hear me?
Yes.
I can hear you.
I can
I
hear-
can hear you. Your
Okay,
Honor, can
good.
you hear me?
Yes,
you hear
I
me,
can
Your
hear
Honor?
you.
Hello?
Hello. I
Hello?
can hear you. I
Your Honor?
cannot see you.
Can you hear me? Okay, Your Honor.
I can't see you.
Is it still frozen,
It's black.
Your Honor?
We have
Okay.
no video.
Can you see me now?
Now it's frozen.
Okay, perfect. My gosh, I apologize, Your Honor. Yes.
Well, it looks like you're driving around. Can you go somewhere with a better connection? Ms. Jennings, I'm going to have
Can you
to
see me
proceed
now?
here. No, I cannot see you. Can
Your
you
Honor?
hear me?
I can see, my goodness. Does it come on now,
No, listen, can you hear me?
Your Honor?
Ms. Jennings, please just listen to me.
Yes,
Can you
yes,
hear me?
I'm right there. I'm gonna pull over right now. Yes, I can hear you.
If
I
we
can hear
can't
you.
get a
I
better,
can hear you, Your Honor.
okay, I need you to get a better connection, or this is the equivalent of not appearing. If you want to participate in this hearing, you need to be able to make a better connection.
Just stop. Your Honor, can you hear me now?
Yes, I can hear you. Ms. Jennings, do you understand why we're here today? All right, Ms.
Your
Winarski,
Honor.
you've been very... Yes? Okay, Ms. Winarski,
Yes, sir.
you've been very patient. I'm going to ask you to be patient for another 5 minutes. I do have a 10:30. Both people are present. Actually, one is physically present, one is in the waiting room, and I believe that's
Your
going to be a
Honor.
very... Hold on, Ms. Jennings. I believe that's going to be a quick hearing, okay? Can you give me 5 minutes, and then I'll come back
Okay.
to you, and we'll see if she has a better connection.
Yes, sir.
All right, thank you. Thank you. Okay, Mr. Boyd, can you hear me okay?
Yes, Judge, I can hear you fine.
All right, good morning.
Morning, Judge.
I took my headset. Usually I wear a headset because without it, sometimes I have audio problems. But the reason I had to take it off is because we have Miss DiBartolo here in the courtroom, and I need her to be able to hear you while you're speaking, okay?
Okay.
So if at any time during the hearing our audio drops, just please bear with me. I can fix it. It just takes 30 seconds. So, Miss DiBartolo, you are Yolanda DiBartolo, right? Okay, and this is 18 CC 1401, and the reason you're here is because you sent in a letter indicating to me that you don't have access to Zoom, right? Can you stand up, raise your right hand, take an oath? You swear to tell the truth, whole truth, nothing but the truth. And can you come up to the podium just to and speak up a little bit if you can? And Mr. Boyd, hopefully you can hear her. If not, I'll repeat what she says.
I can hear her, Judge.
Okay, very good. Okay, your name again is Yolanda DiBartolo, right?
Now, tell me about your internet access or your lack thereof. Okay. All right, and actually, Mr. Boyd, I remembered that I think just maybe yesterday you filed a motion to transfer anyway. Perhaps we should address that first. Do you agree?
I agree, Your Honor. I was going to bring that to the court's attention as well, because I think that would kind of serve two purposes. And if the court would indulge me, I'll go ahead and proceed with that motion, Your Honor.
Let me first of all make sure she's aware of it. Okay, I'm
Okay.
not sure that she's seen it. Did you know that yesterday the plaintiff filed a motion to transfer? Well, okay, I haven't seen your denial, but one of your issues here today is to continue this case because you said you want to get a lawyer, but they need, hold on, let me finish. Because they need more time to get involved and get up to speed. Did you not say that to me in a letter? What were you just saying? Well, the way to solve, I know it's been going on for many years, but originally they were looking for a summary judgment against you. That would be one way to resolve it, but the most recent request is to transfer this to circuit court based on the dollar value in dispute. Do you understand that? That's true. That's true for cases filed after 2020. Your case was filed in 2018. I don't think this is based on fees. This is based on the amount owed, Mr. Boyd?
That's correct, Your Honor.
It's not based on fees. So let me ask you this. You said you filed a denial. This is not really a discretionary issue on my part. If the amount in controversy exceeds the jurisdiction of the court, then I have to transfer it to circuit court. Originally you were, but that has gone up because this case has been pending for 2 years. What I was just explaining to you, that is it's not retroactive. The statute clearly says that for cases filed before December 31, 2019, it's $15,000. Okay, but I just interrupted Mr. Boyd a minute ago because I wanted to make sure you had at least seen the motion to transfer, and you have. You're aware of it. Obviously, you filed in. Hold on a second. Let me finish. I'm going to come back to you. I promise. I'm going to give you a chance to talk, but let me finish first, okay? My whole point here in this initial discussion was just to make sure you're aware of it, and you clearly are. So it's Mr. Boyd's motion. I'm going to let him go first on the motion to transfer, and then you can tell me whatever you want to tell me about that motion, okay? Okay, but do you understand what I just said? Mr. Boyd, go ahead, sir.
Thank you, Your Honor. And again, Don Boyd on behalf of the plaintiff, Port of the Islands Condominium, a resort hotel condominium association. And as the court's aware, and Ms. De Bartolo as well, we did file a motion to transfer jurisdiction of this matter to the circuit court basis, as the court indicated, on the amount in controversy being in excess of that $15,000 figure, which, as the court's aware, is the operative time frame for purposes of determining jurisdictional thresholds. The summary judgment evidence in this case, Your Honor, essentially confirms the fact that the amount in controversy, even without the cost attorney's fees, is in excess of $15,000, just as the court indicated based upon the amount of time that's passed since this action was filed. Accordingly, we're requesting that the court, pursuant to 1.060A, which provides that if it should appear at any time in actions pending in the wrong court of any county, it may be transferred to the proper court of said county by the same method as provided in Rule 1.170J. As the amount in controversy, again, is more than the jurisdictional threshold of the county court, the association would respectfully request that the court enter an order transferring this cause to the circuit court, and the association will agree to be responsible for whatever, fees are associated with that transfer, Your Honor.
All right, thank you, Mr. Boyd. Okay, Ms. DiBartolo, your response to the motion to transfer, please. Sure. And I want you to focus in on this motion, the motion to transfer. Correct. It sounds like you're getting into a defense. It's just the amount in controversy in this court's jurisdiction. I want you to focus on that, please. Is that a rhetorical question? Well, you can repeat it. I mean, if it's something that's on this issue, you can just tell me.
I think there's way too many.
Correct. Yes, ma'am. Well, I'm not considering summary judgment right now. I'm considering a transfer, which in effect accomplishes your original goal of a continuance anyway. So I'm not about to enter a summary judgment. You don't have to worry about that. That means it'll be transferred to a circuit court judge, and then Mr. Boyd would be responsible for setting any hearings or trial in front of that particular judge, not me. Well, the amount is already increased. That's the basis for the transfer. So in essence, what's happened right now is Mr. Boyd is invoking Florida Statute 34, Chapter 34, which talks about the jurisdiction of the court. And you heard him reference a rule of civil procedure, and those rules are promulgated by the Florida Supreme Court. So basically, he's telling me that the legislature, by virtue of the statute, and the Supreme Court, by virtue of the rules, obligates me to transfer this to the circuit court because I no longer have jurisdiction. That's what he's telling me. And based on my review of the authority cited, I believe he's correct. I'm giving you a chance to tell me if you have any legal authority to the contrary. You agree? Okay. So what that means is, Mr. Boyd, your motion to transfer is granted. Mr. Boyd will send in an order to that effect. And then, so you'll fall off of my docket and you'll end up on another judge's docket in circuit court. Okay. Well, it stops you from requesting anything to me, because once I sign that order to transfer, I will no longer be the presiding judge. You then will have to deal with your new judge. I don't know who that will be yet. Does that make sense? Okay. Do you have any other questions? I would suggest in the meantime, if you want to hire a lawyer because you told me you do, then now you have some time to do that. Okay. So you should do that as soon as possible. Don't wait for another hearing in front of the circuit court judge, because then that judge may look back on this hearing and think, well, gosh, in essence, the case was continued on March 18th by virtue of the transfer. So why haven't you done it yet? Right? That's what the circuit judge might say to you. So if you're going to hire a lawyer, do it sooner rather than later. Any questions? Well, I'm glad you have more time now. Okay, so you're not on any docket. You're not going to be on my docket. You're not on the circuit judge's docket yet, but that will happen eventually. So I'm glad you have more time to get that done. Oh, very good. You have a meeting scheduled? Okay, excellent. And so you should tell that judge that the case is being transferred to circuit court. So tell that lawyer, sorry. Tell your lawyer that the case will be transferred to circuit court. Any other questions? Very good. Okay. Okay, thank you, ma'am. Good luck to you. And Mr. Boyd, I'll ask you to submit a proposed order, please.
Will do, Your Honor. Thank you for your time today.
All right, thank you as well. Have a good day. Mr. Boyd is free to sign off and you're free to go. Thank you, ma'am. Good luck to you.
All right, thank you. Well, we're already open on a limited basis, and hopefully we'll be opening more soon. All right. You as well. Thank you. Okay. Madam Clerk, can you hear me?
I can hear you, Judge.
All right, very good. Thank you. So I am once again alone in the courtroom. We have one case of, actually first, Mr. Brewer, what case are you here for? Can you, your audio is on mute, Mr. Brewer. I can't hear you. All right, that's okay, Mr. Brewer. I'm going to come back to you. Let me go back to our last remaining case on the 10 o'clock docket. Ms. Winarski is here for Truist Bank. We also have Ms. Jennings here in 20 CC 1715. Ms. Jennings, can you hear me?
Move to the next one.
Ms. Jennings, can you hear me? Ms. Jennings, your video is frozen and I cannot hear you.
Yes, Your Honor. Yes, Your Honor.
Yeah, you can hear me?
Yes, Your Honor. Your Honor.
All right. Yes, I can hear you.
Gosh, Your Honor. Your Honor. Can you hear me?
Yes. Yes, I can.
Yes, sir. Yes, Your Honor. I can hear you.
And all right, Ms. Jennings, Ms. Winarski has already made her argument for a summary judgment. This is your chance to respond. Go ahead.
Yes, Your Honor. Can you see me?
No, but I can hear you. If you want to make an argument, go ahead.
Yes, Your Honor. The amount is paid in full and no interest charged. So he was supposed to pay me at the time of the divorce of the final judgment. He was supposed to pay me and I didn't get that money. He had never paid me.
You're referring to Jose Santos, right?
Yes, Your Honor. Jose Santos.
So, but the fact that he's never paid you, that's an issue between you and Mr. Santos. That's not a defense to Truist Bank, because this is a joint credit card.
Yes, Your Honor, but it stated the marital debt consists of a BB&T credit card ending in 3827 with the balance, and it says that balance, the husband shall be responsible for half of that debt, and that was the $250 per month.
Well, I'm not sure what $250 per month you're referring to, because of course I'm not privy to the final judgment in the dissolution case, so I don't know what that means.
250 until the amount was paid in full. It says, and continuing each month thereafter until paid in full.
Okay. And that was what Mr. Santos was supposed to pay you?
Yes, that's correct. For this BB&T credit card with the ending in 3827.
So was he supposed to pay you that money or Truist Bank?
He was supposed to pay me the money, and in turn, I would pay them the monthly amount.
Right.
I would turn around and pay them.
Well, and that's what I assumed. So that means you were still obligated to pay the bank, right?
Well, he was obligated to pay me, but he didn't pay me. Yeah.
No, I understand that completely, but that goes back to what I said originally. Isn't that an issue between you and Mr. Santos? If he owes you the money, just because he doesn't pay you doesn't mean you don't have to pay the bank.
Well, I just understood it that there were several credit cards involved, and my credit cards that mine were paid, and the judge, it was stated in this judgment that he was to take care of the BB&T credit card, but he never paid the bills, so that's why they said to pay me, and I always paid them, but he never paid me any money to go toward that. And I took care of my debt with my other credit cards, and the house, is in foreclosure now, and it's been a nightmare.
Well, and I'm sorry to hear that, and I'm sorry that you're going through that. But what Ms. Winarski said earlier is correct. That's an issue between you and Mr. Santos, and possibly the circuit court where you had your divorce case. But that's not a defense to the debt that's owed to the bank. And so it seems like the facts are undisputed. The debt has not been paid, and both of you are legally obligated to pay the bank. Now, he may be obligated to reimburse you 100%, but again, that's an issue between you and Mr. Santos. So let me first of all address Mr. Santos was served. He was also noticed. 2/24/21 is when the notice went out for the instant motion, or the hearing on the instant motion, which was served on 2/8/21. So both the motion and the notice were timely. I do have affidavits in the court file to support the principal amount, non-military affidavits also in the file. And so, Ms. Jennings, again, I'm sorry that you're going through this and it's complicated, but everything you've said corroborates what Ms. Winarski said earlier. Specifically, again, your issue is with Mr. Santos, not Truist Bank. You still owe them the debt. And so the motion for summary judgment is granted. And Ms. Winarski, I'll ask you to submit a proposed judgment to that effect, okay?
Yes,
Your Honor. Your
Yes.
Honor. Would you give me the opportunity? I just don't want a judgment on something that I felt was out of my control. If I could pay half of that debt, would I not get a judgment? And would she be willing to give me the benefit to pay that half, so I don't have the judgment on myself?
Well, what you said there is important. You said, would she be willing? And what I mean by that is it's important to understand, of course, I'm obligated to follow the law. And based on the law that is applicable to this case, she's legally entitled to the request. And we say she. This is not about Ms. Winarski. This is about her client, Truist Bank. And so they are legally entitled to their summary judgment. And so it's not up to me to answer that question. Let's ask Ms. Winarski on behalf of your client. How do you feel about that, to give her an opportunity to make a payment, at least a partial payment, or enter into some sort of payment plan?
I can certainly do that, but it's not 50%. It's joint and several. They're both liable to 100%. So if she wants to call me and see if we can work out a payment plan on the full debt, that's fine, but it's not on half the debt.
Well, let me ask you this, Ms. Winarski, would you be agreeable to this? First of all, the summary judgment is granted against Jose Santos, and you can send in a proposed judgment with regard to him. Okay. And then if Ms. Santos is agreeable, and I think she would be because this was her idea, then we can hold off on ruling. I would take the motion under advisement, specifically with respect to Shelley Jennings. And you all would have an opportunity to enter into a payment plan with this understanding, Ms. Jennings. If you all agree to terms, then you would have to make monthly payments. If you satisfy the agreement that you enter into, then there would be no need for the judgment entered against you. But if you fail to satisfy the agreement, if you miss a payment, then Ms. Winarski would send in an affidavit to that effect saying, Judge, she has failed to make a payment, and I would enter a judgment against you without further notice and without further hearing, which means we don't come back to court. It happens in chambers. So let me start with Ms. Winarski. Would you be agreeable to that?
Well, Your Honor, what I would ask, because I think that might get a little confusing, is if we can just have, let's say, 10 days to withhold submitting anything. Ms. Jennings can call me this morning. If we can work it out, I'll send her a stipulation, then we can file it and send in the judgment. If we can't come to terms in 10 days, we'll just send in the judgment as to both. But I was happy to talk to her this morning.
I agree with the idea of 10 days. I mean, I think that's sufficient time for you all to either reach an agreement or not. If you do reach an agreement, then you would send me notice of that and say, we've reached an agreement and I still don't enter the judgment. And if she fails to comply, but I don't think it would be reasonable to expect her to pay in full within those 10 days. You just want 10 days.
No, I'm talking about a payment arrangement. I'm just talking about getting a stipulation within 10 days.
I agree with that. And if you can't do it within 10 days, then I would sign the judgment because I've already made the finding that Truist Bank is entitled to a judgment legally. So if you're not able to reach an agreement within 10 days, then I enter the judgment. If you are able to enter an agreement within 10 days, then I do not enter the judgment unless Ms. Jennings fails to comply.
Got it.
Okay, Ms. Jennings,
I was just going to say, Ms. Jennings, my extension is 241. You should have our office address on the paperwork. Just give me a call this morning. Okay?
241. Thank you so much.
Sure thing.
Okay, Ms. Winarski, anything further from you?
No, thank you, Your Honor.
Ms. Jennings, anything else from you?
Thank you so much for being patient with this whole Zoom thing. And Your Honor, thank you so much. And I'll make good on this debt. Absolutely.
No problem. All right. Well, thank you both and good luck to you.
Thank you. Sir.
Thank you, Your Honor.
Okay, thanks. Bye-bye.
Bye-bye.
Okay, Mr. Brewer.
Can you hear me now?
Yes, sir. I can hear you, Mr. Brewer. Thank you. I'm just trying to figure out what case you're involved in.
According to the paperwork I have here, it's a filing number 120192399.
That number doesn't mean anything to me. Do you have a case name?
Case number.
Case name.
Okay, case number is.
Case name.
Case name.
Who are the parties?
Ally Bank and Professional Plumbing Systems.
No, I think we've got the wrong Zoom hearing. If you have a number, I can look it up and see what's going on. The case number would have. Yeah, go ahead.
Case number is 11-20-CC-0001-0001-XX.
Okay, so Ally Bank versus Professional Plumbing.
Yeah.
This was originally, let's see, is this even my case? This is my case. I do see that it was originally set on an order to show cause. The hearing was canceled. I'm trying to figure out why that is. Give me just a minute.
Probably because they don't have the right address and stuff on the paperwork, possibly. I don't know.
Well, I got it, and that could be. Notice of cancellation, replevin order to show cause. Yeah, so I don't know what to tell you other than that it's canceled, okay? So I appreciate you showing up, but the other side's not here. The hearing's been canceled. You are free to go.
Okie dokie.
Thank you, Mr. Brewer. Have a good day.
Get a notice?
What do I do about the judgment or whatever they're trying to seek? I just wait on another round of this? Is that what we...
Well, you could do that, or you could try to reach out for the attorney for the other side.
Okay. All right. Because this has been going on for a few months, and I've been trying to get this vehicle refinanced, which they will not do for me. So.
All right. Well, good luck to you, sir.
Okay. Thanks. Bye.
Thank you.
Thank you for the time.
Yes, sir. Okay, folks, when you join the meeting, please make sure your audio is on mute until I call your case, and that may be everyone who's here. I've only got one case set at 11, another one at 11:30. So 11 o'clock is NAF DOF versus Guzman, 20 CC 1318.
Gregory Herrick on behalf of the plaintiff, NAFDOF, Your Honor.
All right, Mr. Herrick, good morning. Ms. Lucrezi is here for defendant. You're on mute. And who is Mr. Wessels? Are you involved in this case?
I represent NAFDOF as an employee.
All right, so Mr. Herrick, he is here for you.
He's my client, yes, sir.
Okay, so Mr. Wessels, you can keep your audio on mute until and unless we or Mr. Herrick decides that we need to hear from you, okay? So you're welcome to listen, but please keep your audio on mute. Okay, so we are here on Mr. Herrick's motion for rehearing or to determine rent in the alternative. Mr. Herrick, you ready to proceed?
Yes, sir.
And Ms. Lucrezi, are you ready to proceed as well?
Yes, Your Honor.
All right, Mr. Herrick, go ahead, please.
A brief bit of background, because the motion that is in question was decided by Judge Brown on an emergency basis. But the gist of this case is that back on September 1st, we filed a motion for an eviction. It was a holdover eviction, also included count 2 for a breach of contract, which has not been decided. But there was a default on the count 1, on the possession count. A final judgment of possession was issued. A writ of execution was issued in between the time that was posted on the tenant's door and the 24-hour period where the sheriff came back to remove the tenant. The tenant hired Ms. Lucrezi. She filed an emergency motion to stay, and along with that submitted the CDC declaration on behalf of the tenant. So Judge Brown had a hearing the next Monday, I believe it was, which happened to be the day that the courthouse was unexpectedly closed due to a tropical storm, but we did go forward without any testimony, but the lawyers had arguments about the propriety of whether or not the stay should continue. Ultimately, Judge Brown decided that the CDC order impacted this case, that the writ of possession needed to be stayed. That is where we take disagreement for multiple reasons set forth in the motion. First of all, there was a final judgment already issued. There was no longer a lease at the time of the CDC declaration or at the time Judge Brown made his ruling. So my position is that the CDC doesn't apply for one reason, being because there was no more lease. The court had already determined that the lease had been judicially terminated. So there's no tendency to protect anymore under the CDC, which puts us in another weird position, because here we are now where there is no lease. We just have a person living in this residence with a judicially terminated lease. There's been no rent paid since, I believe, last July. And to clarify, we did not evict based on rent. We understand that the CDC order does not allow that. It could have been done by rent had there not been a CDC order, but this was a holdover eviction. The tenant's lease was properly terminated with a 15-day notice upon the expiration of the 1-year period. That's not in dispute. What was in dispute at the hearing was that whether the CDC order applies to this situation. Our position is, with all due respect, I think Judge Brown got it wrong. He based his ruling saying 5.5 of the lease, a specific section of the lease, which more or less just echoes Florida law. It echoes 8358, which says if the tenant is a holdover, the landlord can seek double rent. Judge Brown's ruling was that, well, because there is a monetary remedy, then that implicates the CDC order. I think that is wrong. I think we're talking apples and oranges, because we had a possession count, not a monetary count. That was what the final judgment was issued on. And the possession was what was granted. It's the case in every situation that when a tenant doesn't leave at the end of the lease and there's an eviction process, then yes, the tenant has to pay for it. That has nothing to do with whether this person was a holdover and whether possession was granted, which it was. And so the conclusion, if we don't treat it as apples and oranges, that would mean that no landlord can ever seek possession for a holdover. The judge could just say, you can get extra money for it. Clearly that's not the law. The landlord needs to be able to recover possession when a holdover tenant, when a lease ends and when the tenant is a holdover. So for that reason, because I think Judge Brown did get it wrong on the 5.5, because I do not think the CDC order applies to holdover tenancies. The CDC order is explicit in itself that says, it even warns the tenant when filling it out, you can still be evicted for reasons other than non-payment of rent. The CDC order is explicit that it is limited to monetary obligations under the lease, but not other things. And the other thing here was that this tenant's lease was up, it was expired. Besides that, I do think we have the issue that only one tenant filled out the CDC application. So there's a presumption here, I suppose, that she is a protected under this order, a covered person. That has not been tested, and I just point that out because we did not take evidence with Judge Brown at the initial hearing on this matter. So I think there's still the open door, which was the alternative part of my motion, and why my client is here, because the issue is there hasn't, under that affidavit, she swears that she's paying everything she can as timely as she can. That's a bit of an oversimplification, I understand, but there hasn't been a dime paid since last summer. So I think there's a presumption on my end that no, she isn't complying with the CDC order, and we would be challenging her her coverage under the CDC order if it came to that. However, I think the proper solution to this case is that the CDC order doesn't apply because it is a holdover, and that's I suppose I'll leave it for that and for now.
All right, Mr. Herrick, let me ask you a question. I'll give you a chance to respond, and then Ms. Lucrezi, of course, I'll come to you. You had filed the instant motion, I believe in the alternative, a motion to reconsider, and or in the alternative, I believe is how it's phrased, to determine rent. Let's address that secondary request because based on my review of the case, I'm not sure that is appropriate because in fact, as you said, the final judgment has already been entered. That final judgment is still valid. It has never been vacated or set aside. It is still valid based on my review. The judge at the time, Judge Brown, covering for me, simply entered an order staying that final judgment. And so then I start thinking about, well, what's the point of depositing money into the registry of the court in a typical eviction context? You would be obligated, the tenant would be obligated to do that in order to preserve the right to present a defense at trial. But in fact, there will never be a trial in this case, right? Because the default judgment has already been entered. The only question is when the stay is lifted. And so I'm not sure I see the rationale or the reasoning for the alternative request to deposit money into the registry of the court. It seems to me like the issue is just do I lift the stay or not? Am I missing something, or what do you have to say about that?
No, I think that's a fair point, and I think we're sort of in no man's land, like I said earlier, where I don't know what the right answer here is, and it's because we're in an unusual situation where a final judgment has already been issued. There is no more tenancy. The motion was titled in the alternative to determine rent to be paid in the court's registry. Looking at the substance of the motion itself, I think what I'm really asking for in that subsection is a hearing is necessary to determine the party's obligations. So subsequently, when the CDC order was brand new, there was the question of, well, can the landlord do anything? That's, I think, has been settled by now. It's been settled within the courts in this county that says yes. And even the CDC put out an FAQ that said that the landlord can challenge the tenant's whether she's a covered person under the CDC by challenging her CDC declaration. So essentially, that's what I'm asking. The presumption here is that she hasn't paid anything in I think, something like 9 months at this point, not a single dime. So for her to say, I'm paying you everything I can, I'm affected by COVID and all that would be the challenge here in the alternative.
And that FAQ you referenced, just for the record, was issued subsequent to Judge Brown's ruling in this case. Okay, Ms. Lucrezi, your response to the motion to reconsider, please.
Thank you. First, the court is right. The obligation to deposit rent that appears in 83.60 of the statute really applies to whether a tenant is entitled to have a hearing on the merits of a case. And as you pointed out, we are not trying to set aside the judgment or vacate the default. So depositing rent is would not be appropriate. I would first say that the FAQs that plaintiff's counsel refers to is not agency action. It's not even, it's issued as, they termed it a view that that HUD, or excuse me, I'm not sure if it was HUD or Department of Justice, this was their view of how it would apply. And even in that FAQ, although they said they take the view that certainly there are evictions that would not be protected by the CDC, they do not specifically deal with expiration of a month-to-month tenancy. What's important to note about the CDC order is that it deals with covered people, not covered evictions. And if Ms. Guzman is a covered person, she's entitled to the protections. Now, the part of the CDC order that I think plaintiff relies on is that there are 5 exceptions to the protection. Tenants can still be evicted for violations of other parts of the lease. And so the question at the first hearing was, does the expiration of the lease, staying after the expiration of the lease, is that a violation of the lease? And I argued then and argue now that no, it's not a violation of the lease. It gives rise to the parties having various rights. But when the tenant stays past the end of a month-to-month tenancy, they still have rights as a tenant. The plaintiff, if you take the plaintiff's position to its logical conclusion, then as soon as the tenancy is terminated at the end of the 15-day notice, the tenant is no longer a tenant, not entitled to any protections under the law. That's not the case here. Landlord terminated this tenancy by not renewing a month-to-month tenancy. And it's true that the defendant did not file an answer or otherwise challenge the case, and it did come right down to the wire to stay the writ. The fact that the writ was stayed, perhaps while the sheriff was there at the property, is of no consequence. As long as the writ's not executed, it's not executed. And so whether it's, whether the stay was entered 10 minutes before the writ was to be executed or 10 days before the writ was to be executed, makes no difference. The writ was not executed. Ms. Guzman submitted the CDC declaration. She's made those assertions about her ability to pay and the circumstances that led her into the non-payment situation. Plaintiff's position that the proof of her not making best efforts is that they never received anything is not logical. When somebody makes best efforts, it doesn't necessarily mean that it's successful efforts. If she had indeed made some payments to the landlord, it'd be easier to argue that, I know, but what she's doing with her limited funds during this time is not known to us. And so one shouldn't assume that because she hasn't forked over some money to the landlord, that she's not making best efforts to get money together. The bottom line is that Judge Brown's opinion in this case was based on argument presented at that hearing. There's really no change in things since then that would justify a rehearing. I would acknowledge that there have been some other cases that have come out, and that not for our jurisdiction, but which touch on this issue, and I'll bring them to the court's attention. At the time that Judge Brown entered his decision, there was a case, and I'm afraid it's not of record, Morgenstern versus Zapata. It's a Massachusetts trial court case that is very, very similar to what is happening in this case. That was the termination of I think it was a tenancy at will. Judgment had already been entered, and there the court found that the tenant was indeed a covered person and entitled to the CDC protections. Like I said, I apologize that it's not reported and I've not provided a copy to the court or to counsel, but it's the Massachusetts Housing Court, case number 20H77 SP 000440. And I will share that with the court and with counsel when we're done with this hearing. But that case very much tracks the facts of this case and shows that the reasoning that Judge Brown applied to the case was sound and should be enforced. It is true too that there have been at least two federal court cases that decided in favor of the landlord and against the CDC. Both of those cases are being appealed by the Department of Justice. One is from the Eastern District of Texas. In that case, the court made very clear they were not issuing an injunction and that they were, that it applied only to the Eastern District of Texas. And that case is on appeal. That's Turkle versus the CDC. And the citation is 2021 Westlaw 742877.
Wasn't that case more about the constitutionality of the CDC moratorium?
Right. It turned on whether the CDC order was valid under the Commerce Clause.
And they decided it was not.
That's correct. And an appeal.
Sorry, go ahead.
An appeal was filed on February 27th.
Okay, thank you.
The other case that you may have come across and which would be negative to the tenant is Tiger Lily LLC versus U.S. HUD. That's out of the Western District of Tennessee. And I have the order that the order that grants the plaintiff's motion for a judgment on the administrative record. And that order was entered on March 15th, 2021. And it was decided on the basis that the CDC had exceeded its statutory authority. That case too is on appeal. Now, I have the order. I know that it's on appeal because I have some information. I have the notice, or I have some information about the appeal, but I couldn't find the actual notice of appeal. So there are two negative cases out there in the federal courts that talk about the extent of the constitutionality of the CDC order. We're not dealing with that here. Those issues aren't raised, but I wanted, in candor to the court, wanted to bring them up. The Morgenstern versus Zapata case is especially helpful because I think it bolsters the opinion that Judge Brown had issued. And I would also note too that there is absolutely nothing in the CDC order itself that limits it to issues involving rent. It doesn't talk about evictions for non-payment of rent. It talks about people who are covered by the protections. So we would ask that the motion for rehearing be denied. Really, this is just an attempt to get a second bite at the apple. We don't think it's justified, and we ask that the stay be continued.
Mr. Herrick, anything in response to that?
Yes, sure. So Ms. Lucrezi just pointed out 5 other bases under the lease, but here's where we have common ground. There is no more lease. And although the tenant may have rights under an expired lease, and there's no question that this was an expired lease, pending judicial review of that, judicial review happened. This was a final judgment of eviction with the writ of possession issued by the court through the clerk. The landlord wasn't taking action beyond that except to facilitate the writ of possession with the sheriff's office. But this is a judicial determination that the lease was over, the tenant needs to leave. So the other basis for termination under the lease, violation of other issues, is not applicable to this situation because we don't have a lease anymore. We have a person staying on a property with zero authority to stay on that property. And that's a harsh result, I understand, but we're in a weird situation where we're in a gap basically with the CDC order where nothing frankly would make sense, because I would tend to agree. What rent would the tenant deposit into the registry? But what's the alternative? It's not just to stay there for perpetuity with no obligations. So as far as that goes, and the comment of we don't know how Ms. Guzman is spending her money, that's true, but that's why I presented in the alternative that we need to have an opportunity to challenge that, because she may well be using very best efforts, but from on its face, it doesn't appear to be that way, and the landlord is entitled to challenge that according to the CDC's own instructions.
Okay, thank you. Ms. Lucrezi, a couple of comments or questions for you. This order that we're discussing here from Judge Brown was entered on November 10th, 2020. I know there have been some cases, the FAQ that we've all alluded to, that have come out after that date that seem to clarify that the CDC protection is afforded a covered person, protects that person from an eviction based on non-payment of rent. Do you agree with that?
The FAQ does mention that it covers non-payment of rent, but it does not specifically talk about expiration of leases or expiration of tenancies.
I just think that it's been clarified in a number of different ways since Judge Brown entered his order that the protection from CDC is for the non-payment of rent. I think that's fairly widely accepted to be the case, that the protection is if you are being evicted for non-payment of rent. And I agree with you, Ms. Lucrezi. I'm not concerned about the timing of her declaration and whether the writ of possession had been posted or not. I know Mr. Herrick has raised, I'm not really concerned with that. What I'm concerned with is whether this is an eviction for the non-payment of rent. Based on the clarification and the authority, the sources that have come out since this order that clarifies the CDC eviction moratorium applies for to a case involving the non-payment of rent. And this is based on a holdover. The eviction expired. I believe, Mr. Herrick, I read the lease, which is attached to the complaint. Aren't there provisions in the lease agreement that requires one side or the other, if they want to extend it, to file notices in writing a certain number of days in advance? Isn't there a written notice requirement for the extension of the lease?
There are requirements, and in this case, there was a 15-day notice to say that the landlord is not renewing. So that I don't believe is in any serious dispute. But
so the question for you, Ms. Lucrezi, is why would the CDC eviction moratorium apply to a holdover, which is not the same as the non-payment of rent?
Because it applies because being a holdover tenant is not a violation of the lease that would fall under exception number 5 to the CDC order. The FAQs that were issued are just the views of the agency, and I would ask the court to give better deference to the judicial opinion I referred to. Again, I recognize that it's a Massachusetts case. There is another case that preceded Judge Brown, and that's the case of it's out of Maryland, Mead Communities versus Walker, and that's 2020 Westlaw 5759762. There too, the court talks about whether the CDC declaration applies to situations other than non-payment of rent, and it finds in favor of the tenant. I hear what the court is saying, and I would ask court to allow me to submit these two opinions for your consideration before you issue a decision today.
Well, okay, and I'll get back to that. And you have referenced a number of times correctly the 5. You keep using the number 5, the 5 reasons or situations in which the CDC moratorium would not apply. And at this point, I'm not referencing the FAQ. I'm referencing the actual order that extended the moratorium to March 31. So this is the current order that we are operating under, the Department of Health and Human Services, Centers for Disease Control and Prevention, 21 Westlaw 352-179 from February 3rd, 2021. And on page 4 of that is where I believe you're getting those 5 categories. It says, I'm not going to read the whole paragraph. This order is a temporary eviction moratorium. This order does not relieve any individual from an obligation to pay rent, et cetera, et cetera. And then it goes on, this order, nothing in this order precludes eviction based on a tenant, lessee, or resident. And then it lists the 5 things, the 5 different scenarios where eviction, it's not precluded. And number 5, Ms. Lucrezia, I think is specifically what you're referencing. Number 5 says, violating any other contractual obligation other than the timely payment of rent. Okay, and your obligation, or your argument, sorry, is that none of those 5 apply to the instant case. None of those 5 specifically says a holdover situation. A couple of questions for you, though, I guess, or comments, and I'll give Mr. Herrick an opportunity as well. Nothing in this current order from the Department of Health and Human Services says that these are the exclusive reasons that a landlord may evict a tenant other than non-payment of rent. It just says nothing in this order precludes eviction based on the following 5 things. When we consider that in conjunction with, I think, the overwhelming authority that has come out over the last 6 to 8 months that the moratorium protects for the non-payment of rent, isn't a holdover different? I know that they don't use the word holdover, and you talk about violation of a contractual obligation. The lease does say that your term of lease, which is a contractual provision, expires on such and such date. And one allegation here, I think the crux of the argument is that she has stayed beyond the natural expiration of the lease. There are other provisions in the lease, which I just questioned Mr. Herrick about, that require notice. I think that, and I know Mr. Herrick referenced the landlord's option to extend. I think there's also a provision that says if the tenant wants to extend the lease, then she's got to put it in writing and make a request a certain number of days in advance. Those are all other separate contractual provisions, including the natural termination of rent. I'm just struggling, Ms. Lucrezia, quite honestly, to say that's the same thing as non-payment. I don't see that. Another comment I do want to make is, again, in referencing the order that we're discussing from November the 10th, the paragraph 4 of the order says paragraph 5.5 of the lease provides the landlord with a financial remedy. And I agree that it does. Again, I've read the lease. It provides a financial remedy, but to my recollection, I'm not looking at it as we speak. It, again, doesn't say to the exclusion of all other remedies. It doesn't say if there's a holdover tenant, your exclusive remedy is double the rent. And so again, how can you not distinguish between being a holdover tenant and non-payment of rent? To me, it just doesn't seem like the same thing. And I don't think anything other than non-payment of rent is covered by the CDC moratorium. Ms. Lucrezia, do you have any comments on those?
Yes, Your Honor. I think that number 5, that the landlord can evict for violation of other contractual obligations. Leases come in a lot of shapes and forms. A lot of leases are worded that, the end of your term is such and such a date and you shall vacate. And so failing to vacate under that kind of language is a violation of a term of the lease. Other leases just say the term expires. And in which case, if a tenant remains, it's not a violation, a contractual violation, rather. It's a holdover that falls under Florida law and the lease, of course. But it's not a violation of a contractual obligation. The contractual obligation certainly covers things like paying rent, and certainly the term of the lease is set forth. But the lease itself does not include language that says you shall vacate on that date. And if it had that type of language, and some leases do, then plaintiff has a stronger argument to say that staying beyond the expiration of the lease is a violation of a contractual obligation. There's no such language here.
But isn't it implied, whether it's expressed or not, isn't it implied that at the expiration of the lease, the tenant shall vacate?
I don't think it's probably, I would concede that it's probably people's intention, but as the court surely knows, there's lots of leases that do expire and people remain beyond the expiration, and it transforms itself into a month-to-month tenancy.
What about, okay, so I did, I've been listening to you, Ms. Lucrezzi. I've also pulled up the lease that's attached to the complaint. In paragraph 2.2 is captioned lease term. And under subsection D, 2.2 subsection D, again, this is the actual lease. If the tenant desires to renew the lease term following the expiration of the lease term, and then it says in quotes, a lease renewal, the tenant must notify the owner in writing of a desire for a lease renewal at least 60 days. So that's what I was referring to earlier when I said I think that there's a written notice obligation on the part of the tenant as well. And again, Ms. Lucrezzi takes me back to the same question. If she, ma'am, please put your hand down. I see you. I don't know who you are because it says iPhone, but my guess is you're Ms. Lucrezzi's client. But I know you want to speak, but I'm talking to your attorney right now. Ms. Lucrezzi, isn't that another contractual obligation prior to renewing the lease? Again, which is separate and distinct from the non-payment of rent.
I think that it comes close. I mean, I have to concede that it comes close, but it's still not, there's not a command for the tenant to vacate at the expiration of the lease.
Okay. Ms. Lucrezzi, anything further from you? I know you've requested 10 days to submit some case law, right?
That's correct. Nothing,
Mr.
no
Herrick,
further argument.
All right, thank you. Mr. Herrick, anything further from you?
No, Your Honor.
Any response to her request?
I haven't seen the cases she referenced. I think one case out of a Massachusetts trial court out of the who knows how many thousands, the court, I won't object to the court giving it whatever weight it thinks necessary. So if she wants time, I'll agree to that.
Well, I want to read it. I want to read that. I'm not familiar with that case from Massachusetts, but I've referenced cases from Texas and Tennessee, I think have also come up during the course of the hearing. So I think in fairness, I should also consider this one from Massachusetts, which I will do. So I'll take this under advisement, but no longer than 10 days after today's the 18th. So after the 28th, I'll be issuing my ruling. And that's not 10 days for Ms. Lucrezzi to file supplemental authority, and then an additional 10 days, Mr. Herrick, for you. That's a total of 10 days. So if Mr. Herrick, you want to submit any supplemental authority, then you have the right to do that as well. But again, I will be entering a judgment after immediately after the 28th of March, okay?
Very good. Thank you, Your Honor.
Okay, now, Ms. Lucrezzi, we've got someone here who's been raising her hand. Do you recognize her as your client?
Because I'm using the app on my phone, I can't see who it might be. I do, in the last hearing, she was identified as iPhone, so it probably is Ms. Guzman. She planned to be in attendance.
I could represent to the court that I recognize Ms. Guzman from the prior hearing.
All right, thank you, Mr. Herrick. So my question to you, Ms. Lucrezzi, she's waving her hand. I don't know if you want to hear from her.
Yes, Your Honor. I mean,
Okay,
I'd like for her to have the opportunity to speak. I'm not sure what she has to say, but if we give her that opportunity.
Ma'am, you can take your audio off mute.
Hi, good morning. My name is Taisha Guzman.
Okay, and what would you like to say?
Okay, so in reference to that, I supposedly did not give a written 60-day. If I knew I had to keep a copy of it, I was supposedly in contact with a Connor that used to work for that office. I also mailed them the letter. I had found out that Connor had walked out of the office and stopped working. There's a new girl that worked there. I had spoken to her on the phone. And the office manager, I forgot her name, I can't understand her accent. She works from Canada. And verbally, they told me after my lease was gonna expire that I was gonna get month to month to month. When I was trying to pay my rent, they locked me out. I've left multiple voice messages before I stopped having to call to find out what was going on. And supposedly I was given eviction notice. I never received not one. I didn't know anything until the sheriff was here to put a sticker. That's how I ended up with Kathy, Miss Lucrezzi. Other than that, I had been trying, but I was locked out from paying. It wasn't that I stopped paying. I was locked out. And no one has ever answered any of my voice messages. I didn't do that on purpose. And believe me, I'm trying to move. I'm taking care of the property until I move. I've been paying for the water in the tank when it stops working. I've been paying for the septic tank when it backs up. It comes out of my pocket. The air conditioning, I've been out of it for almost a year. I've had to pay almost $1,000 for window units.
Hold on, ma'am, hold on. Stay focused on why we're here
Sorry.
today. Is there anything else briefly? I don't want you to tell me the entire history of your tenancy. Okay, you've got 10 days. Ms. Lucrezi knows that she has 10 days. You're free to contact her and talk to your lawyer. Is there anything else briefly that you want to tell me about the issue that we're here for today?
No, they said I was locked out and I did try and I've left multiple messages. Yes, other than that, no.
I heard you say all those things. Okay, so one final comment to Mr. Herrick and Ms. Lucrezi. Within that 10-day period, if you do decide to submit supplemental authority, that's completely up to both of you. And during the 10 days, you're also free to submit proposed orders on the instant motion. Mr. Herrick, anything further from you?
No, Your Honor.
Ms. Lucrezi?
Nothing further.
All right, thank you both very much. If you're here involved in that case, you're free to sign off and have a great day. Thank you.
Thank you, John.
All right, I know I've got an 11:30. Give me just 30 seconds here for paperwork and then we'll start that case. Okay, I'm sorry about the delay. Our next case is, excuse me, Betancourt versus Horton Holdings, 20 SC 1647. If you're here for that case, then take yourself off mute and let me just see who is here. Mr. Oki, you're here for Betancourt?
For the plaintiffs, yes, Your Honor.
All right, thank you. And Mr. Stevens then for Horton Holdings.
That's correct, Your Honor.
All right, and we have someone else here by telephone. I can't see a name, I can't see a person. Do either of you know who that is?
I do. It's actually me. The audio is through the telephone because I haven't gotten hooked up. The speaker's hooked up to my computer yet, so.
All right. Well, that works then. So that's just have the two of you. And I believe we are here on Mr. Stevens, your client's motion to set aside a default judgment, right?
That's correct, Your Honor.
And are you ready to proceed?
I am.
Mr. Oki, are you ready to proceed?
Yes, Your Honor.
All right, Mr. Stevens, go ahead, sir.
Yeah, assuming the court is well aware of the standard and elements to set aside a default, I won't burden the court too long with that. Obviously, we have to prove excusable neglect, meritorious defense, and due diligence. A quick factual background, which is stated in my motion. My client was pro se. Actually, had hired me to draft an answer and counterclaim that was filed well before all of this occurred in this case. I understand it's a small claims case. The default arises from him not appearing at the pretrial conference that was scheduled in late January. There was a motion to strike that opposing counsel had filed that I had discussed with my client prior to making an appearance. Again, I had not made an appearance yet. He was going to, just to give the candor with the court, that he was going to attend the pretrial conference, try to resolve it. If he couldn't resolve it, I was going to make an appearance then. But I did draft the answer and the counterclaim that are filed by him. The motion to strike was filed by opposing counsel that basically stated that the company was administratively dissolved, and he didn't have counsel and he's a corporation. Obviously, there is an exception in the small claims rules that allows him to represent his corporation if he's the principal of the corporation in small claims. It's sort of besides the point. The administrative dissolution can be undone very simply through the procedures set forth therein, which I advise him he has done.
But the motion to strike was set for January 6th, the pretrial late in January. My client had just gotten back into town, as states in his affidavit or his verified motion. He was having trouble with Zoom. He was requesting a continuance. There were some email exchanges between him and court staff, whether or not it's your JA or another court employee. But basically what had been stated to him is that it had been continued, and his understanding was that the pretrial conference had also been continued. He had nothing else to worry about until his appearance on February 11th, I believe the date is. What actually occurred with the court's calendaring is the pretrial conference was still set for January 28th, even though apparently they're trying to strike his pleadings prior to the pretrial conference, which I think has a little bit of an issue there. But his understanding was that the entirety of the pretrial conference and the motion to strike were going to be heard on February 11th. That is the basis for the excusable neglect that is detailed in my motion. I have provided some case law that I think is very pertinent to it in my motion, specifically in my argument on page 5, actually it's page 6. Here are some instances where the court or the appellate court has found excusable neglect. Basically, what we're relying on is Somero versus Henry General Hospital, which basically says where inaction results from clerical or secretarial error, a reasonable misunderstanding, which we're dealing with here, I believe, a system gone awry, or any other foibles to which human nature is heir, that upon timely application accompanied by reasonable and credible evidence, the matter should be permitted to be heard on the merits. Of course, the case law also states that there is a strong judicial preference to have cases heard on the merits. It's kind of unique here because in circuit or county court, you have to file an answer within 20 days. Small claims, of course, you don't. But he had filed an answer and a counterclaim. Some of the other instances where the appellate courts have found that excusable neglect was sufficient was where a defendant wrote a letter to plaintiff's counsel in court explaining that he was looking to retain counsel and need more time to respond to the complaint, which was timely filed within 20 days after service of the complaint, were enough to constitute excusable neglect. Counsel mistakenly calendaring a hearing in Vias at Laguna Bay Condo Association versus City Mortgage, Inc. Another one, trial court abused its discretion. So here we're undoing a denial of this motion, essentially at the trial court level. Trial court abused its discretion, which is, of course, a very high standard, in denying defendants' reliance upon a letter faxed to trial court requesting continuance of hearing supported finding of excusable neglect. If you look at the email exchange, he's requesting the continuance, and he was under like I said, he's under the misunderstanding that everything had been continued until February 11th, which wasn't the case. The meritorious defense, we don't have to prove any defenses, they just can't be technical. We have filed an answer and affirmative defenses. There's several affirmative defenses in there, which creates meritorious defense. That is easily met, typically in almost every case. Due diligence was met here, certainly. I didn't quote any case law because the motion was filed within about a week after the default. We're not dealing with months or several weeks. But ultimately, I think we're focusing here on the excusable neglect. I also don't, again, I'm kind of go back a little bit with the motion to strike. I mean, I think the motion to strike does need to be heard before a pretrial conference anyways, when he's trying to strike pleadings. We're going to he's going to a mediation, essentially, at the pretrial conference. But I think it's an important fact. But what we have here is a pro se litigant that ultimately had a misunderstanding with the scheduling processes. There's an ongoing dialogue. He tried to appear at the hearing on the motion to strike. He had already filed documents in it. I understand the judge's ruling. The motion, the small claims rule is pretty straightforward. It doesn't appear at the pretrial conference. There will be a default entered. It helps with the administration of justice, certainly. But here we're certainly allowed to set it aside under circumstances that warrant it, and I think that the circumstances here clearly warrant it. I'll go ahead and end my argument at that point.
Okay, thank you, Mr. Stevens. Mr. Oki, your response, please.
Yeah, two quick responses to what was said before I get into the rest of my argument. The first was I need to be clear that any communication from Mr. Horton, from the defendant, relating to a continuance was only in relation to the January 7th hearing. It had nothing to do with the court's hearing on January 28th for pretrial conference. So that's important. Secondly, I disagree with counsel. I don't think it matters that we had a pending motion to strike. The pretrial conference, as noted in the court's notice, is to for the parties to make an appearance, state their position in the case, and so forth. There's no reason why we couldn't pursue a motion to strike before or simultaneously as there was a pending pretrial conference hearing. So now, having said that, my response to the motion is I don't believe that the defendant has shown excusable neglect. And let me first start, and may I, Your Honor, may I please share my screen? Are you able?
I don't think you'll be able to do that based on the settings for this Zoom.
Okay.
You can reference certain documents. Perhaps Mr. Stevens and I have them.
No, I was going to share, I was going to just bring up some case law. But I suppose I can read it to you if the court's unable to make that change on the settings.
Go ahead.
Yeah, so the first case that I would reference to the court is a 4th DCA case. It's 382 Southern 2nd 383. It's John Crescent versus Schwartz. And it just repeats the court's and the state of Florida's stance with regards to what's required of litigants. Yes, Mr. Stevens is correct that the state of Florida prefers cases to be determined on the merits. But on the other hand, it's been repeated many times through the courts that the failure of a party to take the required steps necessary to protect its own interests cannot, standing alone, be grounds to vacate judicially authorized acts to the detriment of other parties. And this is the state standard here. The law requires certain diligence of those subject to it, and this diligence cannot be lightly excused. So that's the first thing, looking at just broadly, the state and the courts require a certain amount of diligence. That was not exercised here. We all know that if the defendant had gone to the clerk of the Collier Clerk of Court through their website, looked up the case, the docket clearly depicts when a case is set for hearing, and if it's canceled, it notices that that hearing is canceled. There's no such entry of cancellation with relation to the court's pretrial conference, only to the January 7 hearing. So a very small amount of due diligence would have prevented the defendant's confusion. Now, additionally, the courts have been very clear that a misunderstanding of a court proceeding or a court document is not excusable neglect. And the case I would cite to, which has been cited to many times, is St. Cyran versus St. Cyran. This is 2nd DCA 1996, 684 Southern 2nd 243. And it was a dissolution case, and the husband filed a motion to set aside, stating excusable neglect, that he did not understand that the notice of hearing was for a final hearing. And the appellate court said that the trial court correctly denied that, and they noted that the failure to understand the legal consequences of the proceedings does not constitute excusable neglect. And that's been repeated throughout all the districts, Your Honor, throughout the state. Merely failing to understand a proceeding or failing to understand and notice is not excusable neglect. And that's essentially what I think the case is. The defendant saying they misunderstood the cancellation of the January 7th to also be the cancellation of the January 28th. And that's simply just a misunderstanding of notice. And that, according to the courts, that's not excusable neglect. My final point, Judge, is the defendant has the burden to show the court sufficient evidence of excusable neglect and to set aside the default judgment. Now, they can do that by an evidentiary hearing, or they can file an affidavit. In this case, it's a verified pleading. But that doesn't mean that they are exempted from the rules of evidence. And essentially what the defendant is relying on in his motion is a hearsay statement from the court's judicial assistant that the defendant didn't have to worry about anything until February 11th. And Your Honor, that's insufficient in that is inadmissible hearsay that the defendant is attempting to produce and for the court to rely on in granting this motion. So that as inadmissible evidence, it should not be relied on. If they wanted to discuss this communication with the judicial assistant, this should have been set for an evidentiary hearing, and they should have subpoenaed the court's assistant to discuss whatever conversation they believe was confusing to them. So for those reasons, Your Honor, we would ask that you deny the motion.
All right, thank you, Mr. Oki. Mr. Stevens, any final response to that argument?
Sure. There's no evidentiary concerns here. You can file it without an evidentiary hearing. I've done it several times prior to my being even involved in cases. He is basically testifying himself to his state of mind as to the conversations that were going on, and that's all that applies to. As far as the notice, there's a difference between not understanding, showing up and not acting like you don't understand what's going to be heard that day, as opposed to being under the mistaken belief that it was going to be not heard that day at all. And again, here is a unique, I've never had one of these in small claims. I don't do a lot of small claims cases because of the expenses associated with it, but the item here that we're also dealing with is that he has filed an answer. He has made an appearance. He has filed a counterclaim. He has been participating. So I think he was certainly diligent. It was miscalendaring. I mean, things happen, and the strong judicial preference is to have these set aside. And this certainly warrants it. There's cases that I've cited to in my motion that I think align with that. Those are the only 2 points I really feel like I need to address of that argument, but that's the state of this case, and a default should be set aside.
Mr. Oki, I gave Mr. Stevens 2 chances. Do you have anything else you want to say?
Yeah, I would just respond that this is not a miscalendering. A miscalendering is when they put the event in the wrong date and then they file an affidavit saying I miscalendared it. That's not what this is. This was the misunderstanding of the notice and that he was required to be there on the 28th. The final point that I forgot to mention earlier is that per the Mr. Stevens' admission today, he's already been retained by the defendant, which means that at any time between January 7th and January 28th, the defendant could have called Mr. Stevens and said, can you look into whether or not that January 28th hearing is canceled? I'm a little confused about that. And he would have gotten an answer from Mr. Stevens. So again, I go back to my point that I don't believe a minimal amount of due diligence was exercised by the defendant, and had the defendant done that, they would have known or appeared for January 28th. Thank you, Your Honor.
All right, thank you, Mr. Oki. Mr. Stevens, I'm going to grant your motion. I understand Mr. Oki's arguments, and when Mr. Oki, when you talk about due diligence, I know you're referencing prior to the pretrial, January 28th, some due diligence would have confirmed that we did in fact have that hearing, as opposed to the due diligence as one of the 3 prongs for the motion to set aside. Mr. Stevens, you're talking about after the fact, and I know that your client came to you within a week and you filed the instant motion quickly, and I agree with that. With regard to his due diligence prior to the 28th, Mr. Oki, I agree. That sounds like a fairly simple, straightforward process. for you, but you're an experienced attorney, especially here in Collier County. It might be different for a person who's acting pro se at the time. And so I do find that the requirements for the instant motion have been satisfied. I'll also note that there is the email attachment does indicate that the hearing was canceled and rescheduled to February 11th, 2021. I just want everybody to understand that that was not from my JA, who was out that time. I know that it has her name on it. That was from Coverage, who was simply accessing her email. And so a subpoena to my JA would not have done anybody any good anyhow, because that wasn't from her, okay? But I do understand the basis for some confusion. I think there's a difference between understanding the legal consequences and simply miscalendaring or misunderstanding whether the hearing was to occur at all. And so again, we'll resolve this on the merits. Mr. Stevens, I'll ask you for an order consistent with my ruling. And I'll also note, Mr. Stevens, just for your information, the motion to strike filed by Mr. Oki has not yet been ruled upon. Mr. Oki, is that correct?
Correct.
That's still pending. And so that may be an issue we address in the future. That's between Mr. Oki and Mr. Stevens. But in the meantime, if you send me the order, Mr. Stevens, then we'll proceed in the normal course. Any questions from either one of you?
Yes, real quick, is the court going to reset the pretrial? Or you want me to put that, make a space for that in the order so the court can put in a date, or how's the scheduling on that going to work?
That is a good question. And I'm hesitating for full disclosure. What happened is last year we weren't doing any small claims pretrials, which led to a backlog, and then we started scheduling extra dockets for pretrials, and and honestly, I'm not quite sure. I don't know the answer to that. So you don't need to include space. I can certainly do it. I can schedule a pretrial, or I can have our mediation department schedule the pretrial, but I don't think I want to include it in the order, is the answer to your question. And of course, you and Mr. Oki are free to talk about this case as well and send in a request. If both of you have a request on how you want to proceed, then let me know.
Certainly, thank you, Your Honor.
All right, Mr. Oki, anything else from you?
No, Your Honor.
All right, thank you, gentlemen. Have a great day.
You as well.
Thank you. Bye-bye. All right, Madam Clerk, I believe that completes our morning docket.
Yep.
You agree?
I do.
Okay, so we are adjourned. Thank you very much.
All right. Thank you.